You think about some of those relationships that maybe you've seen with celebrities, and you think like, well, why, what's going on there? Okay. Well, I don't know. Love is love, right? People marry whoever they choose. But when we're talking about from a divorce perspective and an estate planning perspective, I often get the question, well, are we just going to divide everything in half? Like, is she going to get half of my retirement? Is he going to get half of my pension? What are we going to do? And the short answer is, I don't know, because we have flexibility.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. We're going to do something very different this time. As a matter of fact, I don't think we've quite taken this approach more than once or twice since we started the show 7 years or so ago. So we want to talk about the relationship between a divorce and your estate planning. And of course, this is logical given the fact that Cordell Cordell now has a estate planning division. And the reason it has an estate planning division is because we do see this relationship. And it sort of spurred our decision to expand the umbrella of Cordell Cordell for the first time in our 35-year existence to incorporate something additional beyond just domestic relations. So, clearly we walk our talk on this. We truly believe that divorce bears an important relationship to estate planning, that some of the same issues come up, that often people who have divorces that are perhaps even within just decades of a death, they often make mistakes in their planning that haunt them many years later, not to mention people who have a death shortly after or during the process of divorce. So we'll start off this show talking a little bit about this relationship so you better understand it. We'll also talk about some of the issues. And let me give you a heads up that as we talk about these issues, they're not going to flow in a perfectly linear fashion or even an imperfectly linear fashion, because the nature of this discussion, we've decided, is that it doesn't lend itself to that sort of chain of discussion that I so much like. That appeals to me to do a show in which I can talk about things that naturally flow from topic A to B to C to D. This isn't like that. So what we want to do is hit the big issues so that we cover the things that we think are probably most essential that we at least introduce you to the issues. We don't have the opportunity to discuss fully the many things that you should consider in the divorce process that may relate to your estate planning, whether it's soon thereafter or deep into the future. But we want you to understand the important relationship that exists between these two events. So our goal in this discussion, of course, is to better equip you to be able to deal with the situation if you ever have it arise that you're facing a divorce, or maybe you could in fact be involved in a divorce currently, and the connection between that and the things that you will most care about in the next major similar event of your life, similar in some ways, and that's the process of planning a death. So let's get into it. We have a marvelous guest today. We have with us Wil Halaz. He's a partner at Cordell Cordell, a partner in domestic relations. So he and I will kind of talk about the relationship between these two critical junctures that people have in their lives. One inevitably, one maybe not. We hope people don't end up in divorces, but we know the reality is many do. So Wil, thanks for joining us.
Thanks for having me. I'm excited to talk about this. I know it's not a conversation that we have every day, but it is a conversation that we have with our clients because it's important to think about these things. They are so interconnected, and there's so many overlapping pieces of information that sort of apply to both of these areas that it's important to talk about these things and kind of know, what do I want for the next phase,
Well, and let's communicate clearly. Before we started the show, you made a couple points that I wanted to be sure you raised them again. And you were talking about the similarity between divorce and death in some ways.
Yeah. So, we all hear "till death do us part," right? Those are the vows, right? But we know that's not necessarily true, right? That's why we have divorces. But it's really when we talk about divorces and death, we're talking about the transition. And to me, it's the transition is what we're planning for, is what we're trying to make sure that what your wishes are going forward, to the extent that we possibly can, from a legal perspective within the bounds of the law, that we can make those wishes happen, that we can ensure that your goals are being met, whether it be divorce settlement, divorce litigation, if we have to go that route, or through estate planning, so that we can make sure that what you want to happen going forward after this period of transition is going to happen, whether it be for your family or for whomever your heirs are in terms of a testamentary capacity.
I hadn't quite thought about it the way that you expressed it, but they do bear a lot of resemblance. They both are major, almost tectonic changes in people's lives. If you were to make a list of the 4 or 5 things that are the most dramatic, some cases traumatic, but certainly dramatic changes in people's lives, I mean, whether or not they've been divorced, I think they would say, yeah, I think divorce would be one of them. And people who have been divorced, that may be listed above death in terms of what they think about and worry about. So I think that there are important ways in which these two topics merge, and more so than I thought before I decided to do this show. But I'm ever more convinced. The way we do this show, incidentally, is we'll get together beforehand, like we did here in the studio. We sat down yesterday and we visited about how we can approach this topic, how we should cover these things in a way that makes the most sense and is the most useful. So it started emerging to me during that discussion how, geez, I knew these things were related, but I didn't fully appreciate the similarities. And we started talking about long-term strategic plans we wanted to be in place for many years. And, you think about estate planning, some of the same things. Now, you focus on domestic relations, but of course, estate planning does come up in your practice. I'll bet not as often as many of us think it should, but clients, they have their hands full, their plates in front of them. So our experience has been at Cordell and Cordell that often clients say, look, I just want to I want to survive this.
Right.
And so it's all attention on what's in front of them, which granted is a lot. It's a lot. And it is all these issues that at some point, if they haven't already done estate planning, and even if they had done estate planning, they're going to have to do again. So there is a very distinctive, important relationship here. And it's about time that a show like this was done. I've never seen a show like this anywhere on the web. I've not seen books written on it. I've seen a couple of articles, but these are articles for lawyers and legal periodicals.
Yeah, and I mean, I think it's it all starts with priorities, right? Because when we're talking with clients in a divorce situation, as you said, their priorities sometimes are what's right in front of them. Right.
Yeah. Get me through this.
Get me through this. Just make sure I get to see my kids. Make sure I get to spend time with them. Make sure I'm, then they'll start to think about the financial side. How am I going to go forward with this? What am I going to be able to do financially? Can I, afford the same living conditions?
Can I buy a new home when this is over?
Right. And then as we kind of get deeper into it, we'll start to see some of those other concerns, though, those long-term concerns of, well, what about my retirement? What's my retirement going to look like? Because especially when we start talking about later in life divorces, maybe even a second or third divorce, there are other considerations that are coming up. Children from previous relationships. Like I said, later in life, there is a big question because we're looking at dividing up retirement accounts. I mean, anything that's a marital asset, we're dividing up. So we got to look and see what is maybe more important to this particular client, and how does that then fit into their estate planning goals?
Yeah, and it's sometimes harder to get somebody's attention, even without a divorce, for some of these estate planning considerations when they're in their 30s, for example. And then as decades go on, people are more attuned to this approaching change in their life. So we've talked about the fact that these two things, death, divorce, are related fundamentally. But it becomes even more urgent for those people, those divorces that are occurring in certain situations.
Right.
And now people talk about the gray divorce.
Gray divorce.
And often it may be that it's the gray and blonde divorce, meaning sometimes you have both parties that are old, and that is happening in greater numbers, it seems. It gets more attention.
Yes.
And my wife and I, as you know, spend some time in Naples, and, divorce is happening among people who are in their 60s and 70s. I don't get it. I mean, I really don't get it. I often think it's a mistake unless there's some horrific condition, but still, it's happening. But often, though, it'll be one party is older and the other is younger, maybe 20 or 30 years. But all it takes is for one of the parties to be older, in which you could have this sudden transition from having just a divorce going on to having a divorce and probate going on simultaneously, although technically they couldn't because the divorce process will stop when one of the parties dies. It has to. But are there still lingering issues related to the divorce?
Absolutely. I mean, when you have that circumstance come up, I mean, as an attorney, it's always it's difficult because you're trying to help somebody through this process, and then anytime somebody is deceased, it's difficult, right? But as an attorney, you're trying to anticipate all sorts of things, and sometimes there's just things that don't get anticipated or can't be anticipated. So when we see those sort of I don't want to say red flags because, longevity is a nice thing. That's not a red flag. That's a nice thing. But when we have clients come in who are, it may be a gray divorce or was it a May-December divorce, right? Where it's a May-December relationship. When you see some of those things, that's going to be one of the first things that you're starting to talk about is, okay, what are the priorities here? Because, we want to look at this holistically. We don't want to just look at it as let's get you in, let's divide up your stuff, and let's get you out. You want to prioritize the things that are going to help you going forward live your best life. And, you start looking at those considerations of what is the balance of life for each of the parties. So, we start getting into conversations about if particularly, like you said, I mean, this is sort of the more exciting topic is, when you have those disparities of age, right?
Yeah.
Because those are the ones that make the headlines.
The YouTube hits.
Those make the headlines. And so, you think about some of those relationships that maybe you've seen with celebrities, and you think like, well, why, what's going on there? Okay. Well, I don't know. Love is love, right? People marry whoever they choose. But when we're talking about from a divorce perspective and an estate planning perspective, when we divide up assets, most states come from a perspective of we're going to divide up assets equally or
it's a starting
equitably.
point.
Right.
It's kind of a starting point for discussion. They may not end up equal, but and it also matters if it's community property, right?
Right. So I practice in Missouri, and so in Missouri, our statute says a fair and equitable division. Okay, equitable doesn't always mean equal, but generally it does. But I often get the question, well, are we just going to divide everything in half? Like, is she going to get half of my retirement? Is he going to get half of my pension? What are we going to do? And the short answer is, I don't know, because we have flexibility. We can offset property against other property. And so what may be important to one of the litigants may not be so important to the other one. And so maybe one's looking for more liquidity. Maybe one's looking for more stability in their retirement assets.
And so another way to express this is that some people are concerned about cash coming in, going out, and that's often the lower earner. So if you have that what was a more common scenario in the last century was you'd have a homemaker, then in that case, you have somebody who's going to be really concerned about, I want a certain amount of money coming in now. In some states, judges are not as inclined to award quote-unquote maintenance, but in any case, maintenance is not awarded as generously as it was at one time in America. I think that's fair to say, in most states. So you have one side of the table in that scenario where you have a huge disparity in income where they're thinking about, I want cash flow first and foremost. The other may be thinking, I have plenty of cash flow. I have my salary, and even when I pay child support or even pay some maintenance, I'm good.
Right.
And that person is more interested in or they should be more interested in more a division of assets in which they want something that's going to have value in the future. And I think where you're going is that could have estate planning opportunities.
Yeah, I mean, there's such a variety of different retirement planning vehicles that we talk about tax deferred assets, we talk about just in brokerage accounts, investment accounts. We talk about life insurance policies, whole life insurance policies. Those are a big one, and that's a big one from an estate planning standpoint too. And how that interacts with the divorce process is something where we can get more creative and we can get more dialed in to maybe what that particular litigant's needs are, or utilize that as sort of a bargaining chip, because maybe it's something that the court can't do.
Yeah.
Right.
And that's not unusual. So you might make that clear, is that the court, if a judge is forced to make the decision to divide the assets, where, in other words, no settlement is reached, and the substantial majority of cases in divorce law do end up in settlements. Now, Cordell and Cordell, I'm pretty confident, I'll have statistics on this, I would suspect we definitely try more cases than the average law firm, but that's because our clients may be more ambitious in terms of what they want. Maybe we're more ambitious in terms of what we think that the judge will award after trial. But the general rule is that clearly 80% plus of divorce cases settle. And your point is that if you force a judge to make the order, there are some things a judge can't do. And often a judge will end up saying, I'm just going to divide these assets up. And that could be hugely wasteful.
Very disadvantageous for a lot of people. And to me, the big one that sort of jumps out at me is with life insurance policies. So, for example, we're talking about child support and maintenance. Okay, what we call alimony. Some places call it alimony. We call it maintenance here in Missouri. But with those, if you go to court, and in Missouri in particular, but I would imagine most other states as well, the court can't order the payor to secure a life insurance policy in order to secure future payments.
Yeah, that's unconstitutional, isn't it?
Right. The statutes, and again, this is Missouri, but the statutes say that maintenance or child support terminate on death of the party who's paying. Okay, so you can't then order somebody to maintain a life insurance policy, for example, to secure future payments past their death. It's just not allowed. So oftentimes, however, when we are negotiating these things, we're looking at, okay, well, what's important to you, person on the other side? Well, it might be security, because if my spouse is significantly older than me, but we have relatively young children, that's a concern. And so, how am I going to care for these kids if this person passes away? Because I'm no longer going to get child support, or maybe even I'm no longer going to get maintenance.
And to make it more clear for those who didn't get it, it means that the court cannot order the payment of maintenance past somebody's death. So that's part of the thing with the life insurance. You can't order somebody to pay a debt after they're dead. And for that reason, there's some insecurity about somebody who's dependent. So this is not just a homemaker. This is any marriage in which it's been fairly long, we'll say 10 years plus, and there's a big disparity in income. So that exists a lot. Matter of fact, more often than not, that you have like a 2-to-1 relationships in income. And in that case, that person's, if there are children involved especially, is very concerned.
It's an assumption, but I think a reasonable assumption that's going to be a concern of theirs. That's going to be a something that's high on their want list, right? Because we talk about your wants and needs in a divorce case, and that's going to be high on their want list. Maybe it's on their need list, but it's one of those things that they wouldn't be able to get absent coming to the negotiation table.
And similarly, taking the other side of the table is you may have somebody who, as we suggested a while ago, is more interested in, I'll agree to pay some money now, especially if there's some way to tax deduct it. And in exchange for that, I will be able to keep assets that will have a whole lot of value for my estate later on. So that may be their thinking, especially if they're older.
Right. And not so both for individuals who are older, but also this is something that comes up a lot with individuals who are on either a second relationship, second marriage, whatever it might be. If they have children from a prior relationship, I have found that that has been a big priority for them is, well, how am I going to make sure that, my kids are going to get what I want and then what I want them to get in the future?
Because child support can't be ordered for those children from that dad.
No, not from a previous relationship. It's, it has to go with the biological parent.
Unless there's adoption. But
unless there's adoption, correct. So then we start talking about, I had a client who was very interested. He had purchased a farm a long time, a hunting property, and he had built it up with his sons, and it was beautiful hunting property, okay? Made it a hunter's paradise. And that was one of his priorities was I want to make sure that my children have this for the future. Now, he got married later in life, remarried, I should say, later in life, and he retitled that asset in joint names. So then there's a presumption that this is now a marital asset.
Yeah.
So we had to work through that. But that was one of his priorities from an estate planning standpoint was I want this to be an asset that I can pass along to my children. So we had to kind of structure our settlement around the idea that that was one of those priority pieces that we wanted to make sure happened, and he was able to get that. And so we were able to structure, a buyout. He had some other assets available to him. He had significant income available to him as well. And so it was one of those where we were able to meet that goal. But had we not had that conversation about, well, I want this to be something that I can pass along to my children, it could have been approached just like any other divorce, right? Of, well, okay, this is a piece of real property and we're just going to divide it up and, this is
meaning a judge would order it sold if
potentially, yeah.
Yeah,
if we can't reach an agreement, that's especially with an asset like real property where, maybe you could divide it in kind, but this property was pretty special, at least for him.
And it emphasizes why there's a time to try cases and there's a time to settle them. And some people's propensity is it's always better to try the case. Well, I agree that there certainly are times when a case needs to be tried, and too often lawyers are not willing to try the case because they don't like to try cases or because there are various reasons. But I'm proud of the fact that Cordell and Cordell's philosophy has always been, matter of fact, we call ourselves a domestic litigation firm, to emphasize the fact that we stand ready to litigate when it's in the client's interest. But this is a case that you're describing where if you do go to trial, it's going to be that scenario where the court is probably going to end up ordering some things sold for simplicity,
right.
and it's going to probably result in not only the asset maybe yielding what it should yield under normal market conditions, but also because neither of the parties maybe wanted it to end up quite that way, especially if the party who didn't want it could have ended up getting more in a trade. So there is this opportunity in trying to avoid the trial itself to fashion a settlement that would allow somebody who's more future thinking, they don't need money now, they'll take assets that will have more value down the road to them, right. and the other party might have very different criteria about their cash flow needs. So in that scenario, it is the makings potentially of a deal. Now, another point that should be made here is that talk a little bit about the fact that because you take a current asset, or what accountants might call a quick asset, an asset that's convertible, that's liquid, like cash in a bank, like marketable securities, those are going to have a fixed value, readily determinable. It's here, it can be had now, though in that valuation probably would not be the tax consequences. So in a way, it's like an opportunity to arbitrage because often that asset in the future will actually have a lot of advantages that may not be reflected in the amount you trade it for.
Right.
And so talk a little bit how you look for opportunities to perhaps get a little more credit for an asset that can't be or won't be cashed out for many years.
Sure. So, the first place we look is tax consequences, right? Deferred tax consequences. So things like 401ks, IRAs, oftentimes the first settlement proposal that I'll get from the other side will say, oh, well, we'll let you keep that, $300,000 retirement account and we'll keep the $300,000 house. And I'll say, well, that $300,000 in the retirement account is not equal to the $300,000 in the house. We've got taxes, we've got penalties. You just point out all of the negatives of keeping that asset and then say, okay, well, we'll take that asset because maybe that's what our client wants, but it's going to be at a discounted rate.
At $250, for example.
Right. But then there's other reasons also that may be even more advantageous because let's say we're in a downturn on the market, right? Well, you had, I always just use the example of a stock, right? You had 50 shares of Apple stock in there. Yesterday, it was worth X amount. Today, it's worth X minus 100,000, right? Or whatever. The stock market goes up and down. So if you can, if you're, I hate to say lucky enough, but if you're lucky enough to time those things correctly or be in the right place at the right time, you can make those decisions with your financial planner and with your attorney to say, well, I want to take that asset because I know right now it might be down, but I'm betting on that going up in the future.
And so the full significance of this from an estate planning standpoint is huge. First, of course, since this person will take this discount because it represents market value, is you have to take off the penalties and the taxes. But in reality, in this hypothetical client's case, and often clients of Cordell and Cordell will be in a position where they don't need the cash and they're not going to cash it in. So they're really getting a $300,000 asset that really, you could argue, is worth more than $300,000 given its tax protected status in many ways,
right,
up until the point that you cash out. Okay, so you've just watched part one of this topic, which is rich with things to talk about. And so we're going to actually end up with 3 segments. So we decided to break it into 30-minute segments. So I hope that you enjoyed this, and I hope that you tune in for segment number 2. Till then, take care. This has been Life's Third Act. See you next time.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.